Hi, everyone. Welcome to our last scheduled anti-bullying workshop for the 2021-2022 academic year. And tonight, we are excited to introduce to you our speaker, Dr. Maria Volpe, who will be speaking on mediation, promises, and challenges. I'm sure you really will enjoy it. Dr. Volpe is a professor of sociology and director of the Dispute Resolution Program at John Jay College of Criminal Justice. The CUNY Dispute Resolution Center is a university-wide center focusing on dispute resolution research and innovative program development. Dr. Volpe is an internationally known scholar, has lectured, researched, and written extensively about dispute resolution processes, particularly mediation, and has been widely recognized for her distinguished career in the field of dispute resolution. In addition to teaching and research, she mediates conflicts in educational settings, conducts dispute resolution skills training, administers grant funding projects, and facilitates for a wide range of groups. And at John Jay College, she has created and facilitated town meetings and many dialogues. We want to welcome Dr. Volpe, but we also want to thank her for her guidance to the PSC Anti-Bullying Committee that she's given us as we are trying to combat bullying at CUNY and to move the goals for bullying promotion forward, bullying prevention forward at CUNY. And we want to thank her for all her time in her busy schedule and all her patience and advice. We're going to now do the community norms and practices, and Amy will lead us with that.
Thank you, Clara. PSC community norms and practices. Respect for everyone's worth is fundamental to a university and particularly to CUNY, which was founded on principles of inclusion. We commit ourselves to nurture a work environment that honors the dignity of all, is respectful and free from discrimination, harassment, or bullying. And we therefore agree to respect each other's differences and to create a healthy, safe, and rewarding environment that nurtures, challenges, and supports the community. In order for our community to function in this way, it is useful for its individual members to make the following commitments. 1, I commit to conduct that is mutually respectful and not discriminatory, harassing, bullying, or threatening. 2, I take responsibility for my actions and my personal perspectives, recognizing that there may be disagreements with another's. 3, I will respect everyone's contributions and honor the roles and responsibilities of all members through my words and actions. 4, I will be mindful and reflect on how I might be using or misusing my power and privilege in my interactions. 5, I will intend to be inclusive and support others with the same respect and compassion that I want for myself. 6, I am willing to be an active ally, an upstander, by speaking, intervening, or acting on behalf of a person being attacked or bullied. 7, I will seek to understand others and assume best intentions in all interactions. 8, I will seek to understand other perspectives and avoid making assumptions. 9, I commit to listen actively and with compassion at the workplace and in all union meetings. Thank you. And now I'm going to hand it over to our speaker, Dr. Maria Volpe. Thank you.
Thank you, Clara and Amy, for that wonderful introduction. I'm so delighted to be here, and it's been such a pleasure working with the two of you on the logistics for this session. I'm going to try to get my screen share going. Hold on.
So while you're doing that, I see we have a caller on the line. Can you please identify yourself? Your phone number ends in 5785. Can you please unmute and identify yourself?
Hi, Amy. It's Cecilia. I'm on the
Oh.
road, so I'm calling in.
Okay, Cecilia, thanks.
Sure.
Can you see my screen?
We could see it.
Okay, great. Okay, first tech challenge. So as Amy just went through all of the community statements when we were planning this, we talked about my focusing on community norm statement number 8. I will seek to understand other perspectives and avoid making assumptions. Now, mediation is a process that has the potential to realize this particular community norm. It's an idea whose time has come, and more on that in just a few minutes about why mediation has the potential to realize this. But mediation also has its limitations. It's not a panacea. So tonight, I look forward to having a candid conversation about mediation in the university workplace context. Feel free to raise your hands, post comments in the chat, though it's probably going to be easier for me to recognize hands than to manage the chat, just because my computer seems to be cutting off the bottom of my screen. So if you have a question, just please raise your hand. That would be really helpful. Context is really important when it comes to responding to situations. And I'm mindful that this session on this topic was organized by the PSC Anti-Bullying Committee. How and when should mediation be used is the challenge for us here this evening. For starters, in this audience tonight is probably a very diverse group of individuals, including those who are trained mediators, those who don't know anything about mediation, those who are interested in becoming mediators, those who've tried mediation and just loved it. And then there are probably those who tried it and absolutely hated it. There may be those who just refuse to even try it for any number of reasons, and those who are curious and perhaps confused about it. Mediation is just not a household word. There are no TV shows about it, very little media coverage, no public space that usually showcases it. After even a large-scale mediation, it's very uncommon for a mediator to ever make a public statement. It's widely confused still to this day with mediation. And there's no readily identifiable career path for those who are interested in becoming mediators. Nonetheless, it is an idea whose time has come, and there's no easy way to find mediators on top of all of our conversation and all that we'll be talking about here this evening. So I think I've laid the groundwork for a process that continues to confuse us, and yet it has attracted a lot of attention. My simple agenda for the next few minutes that we're together is to demystify this process, to talk about why it's gaining popularity. It could be a process of choice, but remains limited and elusive. And I also hope that we do have a better understanding of its promises and challenges, particularly when it comes to bullying related situations. So why is mediation of interest? Or why should it be of interest? Let me go through a number of points with you. Conflict, which is often at the heart of a lot of bullying type situations, is a normal part of life. We have to figure out how to deal with it. Mediation speaks to situations where there are ongoing relationships. On our campuses, we have ongoing relationships, the kinds of conflicts that we experience are less likely to be the transactional kinds of conflicts that go on in the more commercial business world, talking about ways to deal with payments or contracts. We're talking about individuals who have relationships with each other. Mediation also emphasizes collaborative partnerships and problem solving, that we have a process here where it'll really does speak to collaboration. It speaks to strengthening relationships. It stresses direct communication between the parties. It embraces inclusivity. Everyone in the process is valued. It promotes the use of the softer skills, the kinds of skills that emphasize good communication, persuasion, working with each other rather than coercion. And it focuses on the future, putting the past behind us and trying to figure out a way to structure how we move on. I've said a few times that it's an idea whose time has come, but we also need to remember that mediation is really as old as humankind. But in the past, in the distant past, the way in which mediation happened was that people used their intuitive skills and knowledge and approach to deal with situations. We didn't have this growing interest that we have now seen since probably the 70s in the United States in particular. The contemporary use of mediation has grown, particularly since the community mediation programs have been engaging citizens in local communities all over the place. In New York City, for example, we have community mediation programs in every borough. In Brooklyn and Manhattan, those community programs are run by the New York Peace Institute, in Queens by Community Mediation Services, on Staten Island by NYCID, the New York Center for Interpersonal Development. In the Bronx, it's the Institute for Mediation and Conflict Resolution. Thousands of people have been trained as mediators right here in our backyard in New York City. There's increasing interest by the legal profession. Virtually every law school now offers either a course, a clinic, some sort of training around mediation. The ABA's dispute resolution section is huge. It's one of its largest sections. People in a wide range of other professions are interested in mediation, but the legal profession is particularly interesting to note, since conflict occurs within a context, and many conflicts do have legal concerns. And so while the legal profession has been incredibly resistant in the past, there is a growing receptivity to mediation. In some settings, mediation is mandated. And that means that the parties are required to try mediation, not to reach any kind of outcome. That's not the goal, but the goal is for the parties to at least attempt mediation. Since May 2019 in New York State, our Chief Judge DeFiore issued a directive known as presumptive ADR, where every case in our civil courts in New York State must try some form of alternative dispute resolution, which includes mediation. That makes a huge difference. In the New York City area, the cases are usually mediated by volunteer mediators for the first 90 minutes. So the first 90 minutes of these cases is free to the parties. If at the end of 90 minutes they decide to continue, they would then start paying the mediator. If they choose to not continue, for whatever reason, the case is not working out, doesn't seem to have promise, they can then continue with their journey in the legal system. In other parts of the state, the mediators are required to offer 3 hours worth of free mediation training. But the important thing to keep in mind here is that in some contexts, parties don't have a choice. Some jurisdictions, for example, child custody cases must attempt mediation to work on the parenting plans for the children. So what is this process called mediation? Perhaps the simplest way to describe it, to define it, is that it's an extension of the negotiation process. There are two individuals who are having differences with each other. They interact with each other. They share information. And at the end of going back and forth, they're able to move on. You and I and everyone engage in negotiation type processes every day. You may have already engaged in some today. If you called up a credit card company, internet company, if you talk to members of your family about what to have for dinner, or what to do this weekend, or to significant others about what kind of vacation to have, go on, etc. You're exchanging information with each other. And on a daily basis, we do reach an understanding with the other and are able to move on. Well, on a daily basis, there are also those situations where we do not reach an understanding with the other, and we reach what is known as a stalemate. The communication between the individuals is blocked, and they have to figure out what to do. What are their options when they can no longer go back and forth? We know that individuals are likely to go to people who they know and who they trust. Just think about that. Who do you go to when you're having an exchange with someone on your campus, at home, anywhere? Even if they don't know the other, we tend to choose people who we trust, who we know. So the options are quite varied in how we proceed. The range, and this is my go-to continuum from A to A, ranges from avoidance to annihilation. And we tend to, hopefully not at the extreme end of annihilation, we tend to be recidivists, repeaters of whatever it is that we use as an option. You know, that old saying, if the only tool you have is a hammer, everything looks like a nail. It's not uncommon to see avoidance as a dominant style on our campuses. People just figure out a way to ignore, avoid each other. Other forms of avoidance are withdrawal, quitting, leaving, ignoring, hanging up. We have all kinds of ways of avoiding, and we tend to think that that's okay. It's certainly much better than the other extreme, annihilation, right? You know, when someone takes the opposition out, it makes headlines. But the avoidance type option that could be pretty debilitating, that option doesn't make headlines. What begins to happen is that it festers. And what we see is a pile-on of, I'm trying to draw around it, you know, it sort of keeps piling and piling and piling and piling and piling. And you can only imagine, people can get sick. I, over the years, have heard of all kinds of physical ailments, whether they're migraines, stomach aches, backaches, you name it. By the time they go to someone else, and in my case, I usually get situations that are pretty far along. It's not at the beginning that anyone reaches out. It's usually when the years have gone by. What we have is something like an onion here with many, many layers. And we have to start peeling back. So what avoidance does is it piles on layers and layers and layers. If we could nip a situation in the bud early on, well, we're only dealing with perhaps the initial situation. But as time goes on, what we have are all these layers. And as you begin to peel away, new situations occur and begin to pile on. It's quite an undertaking. So that while we, on the one hand, think that that annihilation is bad, and we should in fact remove that from the continuum here, avoidance at the other extreme can be equally debilitating and painful. So when we heard some of the kinds of examples involved in bullying, imagine all of them piling up and hoping that they'll go away. By the time anyone reaches out, there's trauma, there's emotions, there are perspectives, there are feelings. It's a very complicated situation. So I'm only going to focus on the third parties that one can go to. There are many other ways of dealing with a broken down negotiation between the parties, individuals who can't talk to each other. And there are many in this spot right here. I'm only going to focus on mediation and the processes that it's usually contrasted with. So it's usually contrasted with arbitration and adjudication. Both arbitration and adjudication are decision-making processes that result in win-lose type outcomes. Mediation is a process where we're looking for common ground between the parties, trying to figure out how we can reach, and you'll hear this a lot from people who talk about mediation, for a win-win outcome. Now, that win-win is not 50-50, but individuals will take out of the process what works for them. So the big thing to keep in mind here is that we have a process called mediation where the outcome is the parties trying to figure out how they're going to come out of this feeling like they each won or perhaps each lost, and another kind of set of processes where the individuals end up with a win-lose, an adversarial process. And here I illustrated them just a little bit more. Where one goes to does matter. When you go to arbitration or adjudication, the outcome is a decision made by the third party. That's really important to keep in mind because the parties, A and B here, are each presenting their version, their truth, their story, their facts to that third party. That third party will make a decision. The big difference between arbitration and adjudication is that arbitration tends to be like a private judicial system. It's private judging. We have it at CUNY. Our cases usually go to the American Arbitration Association. On some campuses, there are some hearings that occur. It's basically an arbitration process. It's a private judicial system behind closed doors. Adjudication, on the other hand, is a system that we associate with our courts. It's more formal. It's based on rules of evidence and procedure. It's much more costly. It's much more time consuming. Need to deal with motions and rules of evidence and procedure, etc. So there arbitration is an alternative to the adjudication system. It is considered faster and less expensive than adjudication, but increasingly we hear about mediation as the process that is even less costly, even better than the parties, because in the arbitration and adjudication, the parties are engaging in an adversarial process. There will be, as I said before, a win-lose outcome. In a mediation, the mediator is there to basically help the parties to reach their own outcome. There to help them to have that difficult conversation, is there to help them to find common ground. So the gist of this is that mediation is often contrasted with these adversarial processes. Mediation is considered a more collaborative process, and it's seen as less confrontational. It would be the so-called perfect process for us to use on our campuses. The parties get to share their feelings, their views, their issues, their understandings, their truth to each other. So bottom line is that mediation is an opportunity for individuals to have a difficult conversation with the assistance of a third party. If it doesn't work, they would have available to them all the other options that they could have used along that continuum from avoidance, and I dare not say annihilation. I mean, they have available to them anything and everything. So the reliance in these mediation processes is on the mediator. And that's really important for us to remember. If we're relying on this third party, what kinds of qualities are we looking for? And I only listed some of them. We could go on ad infinitum here, but you want someone who's a good listener, who's open-minded, non-judgmental, tolerant, trustworthy, reliable, patient, persistent, indefatigable. Some mediations can go on for hours, days, months. Someone who's approachable. In one of my research projects on barriers to minority participation in the dispute resolution field, one of the African-American mediators talked about the likability factor. And it really resonates. Someone who is likable, someone who's, as I said, approachable, a people person. We also usually need someone who's knowledgeable, perhaps even a subject matter expert, depending on the situation. Within the university context, it's helpful to have someone who's knowledgeable about all kinds of personnel policies. What does it take to get tenure, promotion, all the different jargon that we use around all of our personnel actions. The one quality that we keep hearing about over and over again is someone who can be neutral and impartial. And I put that in quotation marks, neutral. Yeah, we want a neutral person, but dare show me a neutral person, someone who has absolutely no views. Everyone has views. Everyone has implicit biases. Everyone does, even those who work really hard at it. What mediators have to do is figure out a way for those implicit biases to not surface in that process, so that we have that process that we talked about, that inclusive process for everyone. That's a real challenge. And lately we're hearing more and more concerns about this notion of neutrality. Lived experience brings us to the table with a whole bunch of experiences. Someone reminds you of someone, someone sounds like someone. This situation is something that you may have experienced. How do you control all of that? Ideally, for this process to work, the parties also need to be ready, willing, and able. Sometimes they're ready to go, but they're just not willing. I can't do it. Sometimes they're able to do it, but not willing to do it. They also have to be able to trust that mediator. It's interesting. I often get requests for mediators from people outside the university for very specific kinds of qualities in a mediator. One was from an Orthodox Jewish woman who wanted an Orthodox Jewish mediator for her son's divorce. Another was from an African-American woman who was a mediator who was interested in a Black male mediator in the 50-year age range, because she knew that her husband probably wouldn't trust someone else, but she thought that it would work if there was someone in there that he felt comfortable with. Not unusual to get requests for divorce mediation where they want someone who has subject matter expertise, for example, around estates or pensions. So for mediation to work, the parties really have to feel that they're going to go behind these closed doors with someone who they trust, because unlike the courts that could be open, public, there are rules of evidence and procedure, we're not governed by any universal kinds of policies, principles, procedures. Okay, so what is that process like? Well, it's confidential. It's important that it's confidential. Why? Because the parties are going to share their perspectives, their views, their emotions, their truth. Many don't want the whole world to know how painful a situation has been, or even see them cry. It's a voluntary process. We talk about parties participating in the process voluntarily when it comes to mediation. Now, a few minutes ago, I talked about mandatory mediation. We see in a number of contexts now where parties are mandated to try it, but not to reach an agreement or an outcome. They have to show that they made a good faith effort to attempt to reach an outcome with the other side, but not that they had to reach an outcome. This process, and I've said a few times now, is private and it goes on behind closed doors. That does create walls because people don't know what this process looks like, what it sounds like, what it feels like. We often find out from parties who've been there what mediation is like, but we don't have, as I said before, TV shows or the media reporting on me, even if they wanted to. For the most part, people will keep those doors closed. I often refer to it as a pretty high wall, and it's like a gated community. We don't know what's going on behind the other side of the wall. And that creates other concerns as well. In addition to parties who might use it, people who are interested in becoming mediators often can't find out what's going on. It's hard to attract young people because unlike many other professions where they could even read about it, it's hard to find information about this process. The process is future focused, and some mediators will be so determined to have the parties only talk about the future, but the parties feel that they need to unload some of the past in order to move forward. And another quality of this process is that the mediator, as we said, does not make decisions. The parties themselves are relied on to decide what's best for themselves. Some don't know what's best for themselves. Some would like guidance. Some would like others to make decisions. if that's the case, this process just won't work for them, because you have to be able to think through what it is that you want. How do parties get to mediation? Well, ideally, parties would know about mediation, would have all this information that we're talking about this evening, and request it. And there are some individuals who are at that stage who know about it and say, this is the process I want to use. If they don't know about it, there might be those who have significant others. I use that term very loosely here: family, friends, colleagues, people who we hang out with, who know about it and encourage them to use it. Or the gatekeepers, and again, I'm using that term very loosely. It could be any of the units around the university where people go to either file complaints or talk about concerns. Could be HR, could be academic affairs, student affairs, union reps. There are any points of entry where all kinds of concerns get reported, get discussed. Those individuals could also, because many of them get some of these concerns early on, they could steer them towards a process of working with the other to try to deal with the situation. And then another way that I've mentioned a few times again, is that people could be mandated to try mediation by those who are in authority to do so. Not unusual, and I'm not talking about bullying situations here, but situations around the university where there are all kinds of issues around interpersonal situations, where provosts, deans, vice presidents, presidents, others have said to their staff people, you have got to work these out. You've got to try mediation. And they have. And in many instances, it's worked out nicely. We could also have a policy that mandates that we try mediation for some situations. Again, we have to be very careful that we don't hurt individuals any more than they have been hurt, since tonight's focus is on bullying. So what are some of the challenges of mediation? Not all issues are mediatable. I know that you will probably hear from some mediators that any issue is mediatable and that they could mediate any issue. I'm not convinced that every issue is mediatable. There are situations where there are power imbalances. And remember, those parties are in the room with each other, speaking in their own voice to each other. They may not feel comfortable. They may not be able to deal with the kind of relationship that they've had, because individuals are coming to this process with a lived experience with each other, where there are power imbalances in this process. And the reason I'm going through the micro details about the mediation process is so that people understand what's really involved in this process and what kind of heavy lift it takes, particularly by those who've been bullied, to be in that room. So we have to be really cautious, and especially if, as I mentioned earlier, the layers have started collecting, it gets harder and harder. The parties are relied on. Some individuals have a hard time being in face-to-face sessions, may be uncomfortable, may feel unsafe, feel overpowered. The enforcement of these agreements is uncertain. So even if you went through a process, it's really hard to get these agreements enforced. Usually if, in another context, if one was in court and the judge orders parties to mediation, they reach an agreement, they bring it back, the judge approves it, and it has legal bearing. When parties reach agreements and there's often no way to enforce them, and if an compliance gets started, and one of the parties doesn't adhere to it, it's still hard to get the agreement enforced. The harmed party may be traumatized or re-traumatized in these sessions. Be very careful. The process itself may be abused. One or both of the parties may be using it for discovery purposes, has no interest or intent in actually working with each other and trying to deal with whatever their concerns are. Some parties may not participate in good faith. Some may remain silent and, another form of avoidance, but not really participating in the process. It's hard to, a challenge is hard to distinguish sometimes mediation from other kinds of related processes like restorative justice, counseling, social work, therapy. Often these days, we hear a lot of overlap between restorative justice and mediation. The restorative justice people don't adhere to the confidentiality to the extent that mediators do. And in restorative justice, there's usually the acknowledgement of harm before the process gets started, so that the harmed person knows that at least there's some hope that responsibility is being taken for the harm that's been created. There's no way of verifying the veracity of the parties who are involved. You could say that you regret doing something, but how do we know? I mean, there's no way to discover or to serve subpoenas in these processes. So we're at the mercy of what someone says. With restorative justice, it also tends to include more people in the community so that friends or significant others can participate. It's more of a process for the harmed, the offender, the person who's harmed. We don't like to use the term victim, but that's the person who's been harmed. It includes the parties themselves and significant others. And the intervener doesn't say that they're neutral like mediators often say. So the process is a little different. The outcomes could be the same. One could be restored as a result of mediation. And then during the course of a restorative justice process, some forms of mediation can go on. So there's a lot of interchangeability there between restorative justice and mediation. And there are no universal certification standards for mediators. So it's really hard for someone who is willing to go into the process to check on the credentials of someone, to compare individuals. There's no storefront, no hospital, no precinct. It's not like any other field where you could see or compare individuals, and anyone can hang a shingle as a mediator. So it's one of those processes that truly is still going on behind closed doors and remains elusive to the public. The mediation agreements that are reached at the end of the process are usually non-binding. We usually rely on the parties to comply with whatever they have come up with, but it's basically up to them. If a court has ordered a mediation and the parties reach an agreement, that agreement can be converted into a binding agreement between the parties. But again, usually those are court-ordered kinds of situations. If ordered by and approved by a judge, they can be converted to a binding status. If these agreements are not complied with, the individuals can proceed with other options, all the other options that they would have had available if they had not gone to mediation. They're still there waiting for them. How can mediation work? This is where we get into dreaming about how this process can work. So it would be really important to have a diverse pool of trusted mediators available, people who parties feel comfortable with. Who can you trust in the process? I mean, just imagine yourself behind closed doors with someone. Who do you trust to be with? All the qualities that we talked about before. The process should start as soon as, and I use the term conflict loosely here, as soon as it emerges, to encourage people to get involved in trying to deal with the situations at the outset as soon as possible. So this would mean, for example, anyone who's in an informal, or anyone can do this informally. So you know, two individuals who are having differences, there's no reason why you could not be the person in the middle. But for sure, supervisors or the gatekeepers that we refer to could engage employees at the outset of, I'm using the term disagreements loosely, but when there's tension, when there are situations, if we're going to talk about mediation, anyone can be in the middle. Prepare these parties to have a conversation. This may mean helping them to rehearse what they're going to say to each other. I've had that many times. Individuals don't know what to say, how to start the conversation with each other. Help them to rehearse what they would say to each other. I know some mediators think that you can and should bring the parties together immediately, because after all, mediation is a process that helps the parties to have this difficult conversation. I, over the years, have realized that it's really important to meet with the parties separately before you bring them together, so that they get to share their concerns, they get to hear what the process is like, they get to meet the mediator. Bringing them together prematurely could be really dangerous. And as I said, help the parties to rehearse their options, to consider resources, including self-help techniques, when you hear something, how to respond, or to think of meditation to calm oneself down. Mediation is a way to deal with the outer situation, with the external conflict, with the external differences that the parties are having. Meditation is one where one takes care of one's internal self, calming oneself down. And this is where I think it's been really helpful to see the work of the Anti-Bullying Committee, creating and supporting a university culture focused on dignity. Donna Hicks, who's at Harvard and has done some groundbreaking work around dignity, distinguishes between dignity and respect. She says that dignity is our inherent value and worth. We are all born with it. Think of a baby. A baby has done nothing from day one, and yet is one who expects and is given dignity. It hasn't done anything. when we think about respect, according to Donna, that's something that's earned. It's earned because of one's status, one's wealth, one's position, whatever. It's dignity that we should be striving for. Respect is different. It's earned, and we attach value to that, however that is based on our lived experience, our values, etc. Dignity, think of the baby. Everyone treats that baby as a precious individual. Now, with that value and worth also comes vulnerability. And what we have to try to do is to reduce the vulnerability. These two terms are usually confused. People want to be treated with respect, but usually what we want in many of our situations really is dignity. So a new way of thinking about both dignity and respect. And if only we could create and support a university culture that treats everyone as a valued member of the community, regardless of who they are, whether they're student, faculty, staff, whether they're leadership or not, everyone is worth the same as a human. Respect is different. We should respect everyone regardless of their position. But it is something that's earned, and some individuals are treated with respect, but the question is whether they've really earned it. Design and build systems to support a process like mediation. We need policies, rules, mechanisms that are in place and encourage, support, endorse, and increase the overall knowledge base and ways to make talk work, so that when individuals have differences with each other, when situations occur, we have in place the architecture that supports that culture. And so there's sort of an interconnection between the culture and the infrastructure that we have that provide us with a community that makes it plausible for us to use a process like mediation. I think that we have to be very careful. While we think that mediation is wonderful, and it is a wonderful process, but it's not a process that can easily kick in when someone has been humiliated, fears the other, has experienced hatred, loss, physical conditions. It's really hard to have that person sit in the room with the other side, share all their concerns, and perhaps come out, even if they did come out of it with some sort of understanding that there's no way to enforce anything that comes out of that process. This might be a good time, and I haven't been checking the chat, but to take some questions, since the last slide that I would share would be a sample agreement of what parties are given before they go to mediation. But I'd like to take some questions, comments, concerns.
We have Lizette's hand raised.
Lizette, go ahead.
So good to have you here, Maria.
It's great to see you, Lizette.
Yes, Maria, as you are talking, I keep thinking about so many things, and what Paula was saying resonates to me just as it did to you, and how difficult it is to consider that mediation could work for moments in which you have been so badly hurt. And that's why I keep thinking, okay, so in what way could we use mediation as part of a possible alternatives to address the issues that are happening in our campuses? And I keep going back to your last roundtable discussion, the breakfast discussion, and I urge everybody to join you, because it's once a month, and I have learned a great deal about so many topics in mediation and conflict resolution. But I would like to bring up two questions. At one point, I asked you, why isn't the university using your center to address the issues of bullying through mediation with people that know the academia, know the intricacies of CUNY? And that was left like, it's up to the new chancellor. That was the answer at that point. And I don't know if that still is the one of the answers. But the other one goes back to the last roundtable discussion, in which it was mentioned the need to recognize that neutrality. We cannot keep staying neutral when we are addressing mediation. And I would love you to link that to the many harm that has been created in our campuses, and how difficult it is for us to even ask for help, or go to what you were saying, one of the gatekeepers, the human resources office, just to mention one. It's very difficult for us to go there because we don't trust, or we don't trust our chairs, or we don't trust our supervisors. So I don't know if we could think about mediation as a tool. I love your idea of restorative justice, but I just want you as a member of CUNY to get us into the context of what could be possible alternatives for us that will work in addressing bullying. And I really thank you for all your work. Thank you.
Yeah, it's a heavy lift. I mean, we live in a larger culture, and in many ways, the university is a microcosm of the larger society, right? So in our larger society, when people have differences with each other, they tend to say, I'm going to sue you, I'm going to call the police, and we're going to call others to make a decision. It starts very young, even, in the household. Little kids have differences with each other, and they're going to call mommy or daddy to make a decision. So we carry that through to our institutions. When situations happen, we look to others to make decisions. So reversing that culture is a really heavy lift. Even individuals who are trained in mediation will often say, well, I'm not going to go to mediation, I want someone to make a decision here. I've heard that many times. It takes a lot of courage to have what we call that brave conversation, or that courageous conversation with each other. To be able to control one's biases, to be able to step back. Bill Urey, in one of his works, talks about a technique that we should use to be able to deal with the kinds of situations that we experience. He suggests that we go to the balcony and to look down on a situation. So whenever even we are involved in a situation, it's helpful for us to think about what it would be like if we went to the balcony physically, think of it physically, and trying to understand what's going on here. So it's sort of detaching yourself from that situation. So back to your questions. Why isn't the university using the Center for Bullying? Well, for all the reasons that I mentioned, it's really hard to use a process that doesn't have the so-called teeth that, for example, going to a process that allows you to file a grievance, to put the matter on and put the other on notice, to maybe get some official recourse to the situation, being able to get a transfer, being able to get something out of a situation, because mediation now is putting, as you eloquently stated, individuals who've been hurt, who have been humiliated, in the same room with the other to talk one-on-one about how they could work out their situation. It's hard to get parties to go to that kind of process. So to say to someone, you must attempt a mediation in a bullying situation may make that person feel that they're being further bullied, further harassed, further discriminated against, and perhaps even make the university even more vulnerable in any litigation. So I do get called upon to do a lot of interventions, and am really cautious about meeting with the parties in advance to make sure that they feel ready. And sometimes it could take weeks and months for parties to feel comfortable in meeting with each other. It's not quite as simple as it sounds. People who've been harmed and hurt really have a hard time feeling like they can go into a room and they want to talk it through, and they want to repeat it, and they want to really think about options and talk to others before they come back. So should our gatekeepers, should those that we go to for help be better informed about mediation? It would be helpful. Yeah. I mean, we could benefit from mediator-like behavior. And what that means is that there is someone there that everyone feels comfortable going to sort of have. On a few of our campuses have an ombuds person. I'm not sure how many of our ombuds people are IOA, International Organization of Ombuds People, or International Ombuds Association, IOA. How many of them are trained as ombuds persons? It's not uncommon in the university setting to sort of pick a person who's seen as some of the criteria that I mentioned before: a good listener, someone who's approachable, who's likable, and say to them, hey, would you serve as an ombuds person, so that people will have somewhere to go to. As the students once told me, when, and this goes back during those takeovers at CUNY, some of you may even remember them, the administration was interested in creating an ombuds person, and the student said, if everyone was doing their job, we wouldn't need an ombuds person. We don't need people who are going to be tools of the administration. I mean, it's their perception of what an ombuds person would be. So it's really important that that ombuds person be someone who is truly seen as an independent person. The ombuds people usually report to the CEO of an organization, a university, etc., and have access to everyone on their campus in order to be able to do their work. We've had a number of conversations about that at CUNY over the years. We got close a number of years ago, but at that time, the trustees decided to go with an EAP program. So it's not like we haven't tried some version of these processes in the past, but it takes a major commitment of resources, of structures that this person would have to, and when they call up, when they ask questions, people are going to respond. Otherwise, they become ineffective. So this notion of neutrality is an interesting one for the mediation field, as you mentioned, Lizette. it's really important to have people who are open-minded, who are seen as approachable, so that all sides can feel comfortable going. And yet, there are situations where one wonders, is neutrality the correct or best approach to a situation? And that's where the challenge comes in. It's a process that prides itself on providing all parties with an equal platform, that it's inclusive for all. But are we giving individuals access that perhaps shouldn't be in that forum? For, you know, the offense is so egregious or so inappropriate. The power differentials are so great that there's no balancing of power. The powerless person is going to feel voiceless in that process. Better off going to an adversarial process where the third party listens and then makes a determination. No easy answers here. Paula?
Thank you for calling on.
You're muted.
Yeah, I've been an attorney for in excess of 33 years, but I'm a lawyer here at Medgar, at CUNY. For the record, I'm a healer, and I wish to offer my skills to the survivors of bullying. It's cruel. It's not in your head. I'm available for healing for the bullying survivor. I'm at Medgar. There's life after bullying. Funnily enough, I didn't know it at the time. After 7 hours in the emergency room, 2 weeks of sick days, and losing my position. Luckily, I landed on my feet. I mean, my job is even better than ever, but it shouldn't have come at a high price. There's life after bullying.
Thank you for sharing, Paula. Amy?
Oh, we have a question from a participant. How do we know that the person presenting the complaint first is not the bully, trying to intimidate others through this confrontation?
You know, that's probably the $50 million question in a lot of contexts. Or, you know, a parallel situation where one files and then the person you're filing against files a counterclaim against the person who initiated. So these processes are vulnerable, and it's not just mediation here. It could be any number of different processes that people can misuse. As I said before, it's hard to detect or to investigate veracity in some of these processes, particularly since it's not like a lot of other situations where you might be able to get receipts or contracts or something that's tangible. You know, as Paula has been mentioned, we're talking about emotions, feelings, things that we experience that are not tangible. We can't quite collect all of these items and assess them. We're talking about what's inside. And so can people misuse these processes? They can. And it's unfortunate. The more information we put out about how to deal with situations, I think the better we are. But this is a heavy lift, as I know everyone who's been working on the anti-bullying committee knows, you know, putting infrastructure in place, trying to think of the culture. Haven't even started with all the trainings that might be needed. Having referral sources, having support groups. There might be any number of ways in which the union could be really helpful here. And just having the support groups, having resources available, references, so that individuals don't feel like they're alone, don't feel like, feel helpless, powerless in these kinds of situations. Clara?
Is that me, Clara?
Yeah, your
Yeah,
hand.
yeah, I heard Lizette raised a very good question in the chat. Given that often power imbalances impact mediation, and that we have so many, usually with a bully and a target, there's a power imbalance. How would mediation work at CUNY?
As I said, those are among the most difficult ones when we have these power imbalances. And the question is whether some of those cases even should be in mediation. We don't have a way of leveling the playing field there. We can try through the rules. Each one has an opportunity to speak. No one can dominate. There are informal rules, ground rules that we use. Meet with them separately. But mediators are not supposed to give advice. There's okay to give information, but not make decisions, to not give advice to the party. So you can see it is a process that's limited in trying to balance power control that one of the parties has been accustomed to and may think that they can do it in this setting as well, which is another reason that it's really, really important to pay attention to who the mediator is. Imagine, for example, an accomplished, and I mean accomplished, mediator who's an assistant professor mediating a situation between a full professor or a distinguished professor and an associate professor. Well, the difference in status may make it hard for, especially if that assistant professor is untenured, may not feel comfortable, during that process, making sure that the situation that they have outside that room doesn't get replicated in that room, that the power imbalance, even in terms of whose voice gets heard longer or louder, happens in that room. It's challenging. It's challenging in terms of how do we balance the power. People like George Mitchell are often called in because by virtue of who they've been in their life, the kind of lived experience that they bring, the parties actually like sitting at the table with someone like him, whether it's in Northern Ireland or the Middle East. He's someone that they respect. They probably won't out-talk if he tells them to hold back, they may. Do we have those kinds of individuals available? And as I mentioned, he doesn't have a day of mediation training or an hour of mediation training in his life. He's someone who brings to the table a persona that's full of experiences. For whatever reason, people, in this case, respect. It's been earned through his work, as a Senate Majority Leader and other political offices that he's held. Think of the other people who could play that role. Who would people go to on your campus if there was a power imbalance situation that would make sure that the person who's had the access to power and being able to use it is equalized in a room behind closed doors?
We have another question in the chat. Does PSC CUNY have mediators?
I don't think I'm the one who can answer that question.
Faye answered it in the chat. She's Faye Moore, our contract enforcement. She has just indicated that no, the PSC does not have mediators.
I have mediated situations where union reps have been involved. They've played a role. Also wanted to leave the room and left the parties in there with me, told them that they were in good hands. And fortunately, in those situations, it did work out. But yeah, that's been my experience with the union. They have been in the mediation room and left once the process got underway. That was the extent of the involvement. I, depending on the situation, have consulted with union reps, particularly where there have been grievances involved. What else could they add to the situation? I think that they have to respect the mediator and know that whatever they know will be held in confidence as well, because they have to be trustworthy to their members. So the mediator really does carry quite a burden with this trust. Everyone has to be able to trust this person. I'm not going to talk about any of these cases here. It would be great to share, but I can't, because I would feel that would be a violation of the sacredness of what these individuals have shared, that we would be talking about their innermost feelings about each other. I don't talk about the cases that I've handled around the university. There's a question, does Maria's office have restorative justice training or any other training opportunities? Well, I think we were more successful in doing the training stuff many years ago, where we did do a number of faculty development programs, one-day programs. I see, Lizette, you're shaking your head. I don't remember if you were part of those way back.
I have been here since 1982, Maria. Yes.
Yeah, so you probably were. Over the years, I think we've done it all. We've done workshops, we've done trainings. We have also, in the not too distant past, interestingly, when we started the sexual harassment program at the university, the informal resolution part of the sexual harassment included mediation training. Everyone who was at that time a panelist, different than the process is set up now, but there were panels on our campuses of faculty, staff, in some cases even students, used to go through at least 2 days of training. And then there was some concern that the mediation field was beginning to develop professional standards, and there was a concern about whether the university might be at risk if the individuals weren't really as committed to being a mediator as professional mediators, that we changed it to informal resolution. And there was 1 day of training around conciliation, of meeting with the parties separately, maybe engaging in something like mediation, but not calling it mediation. These processes keep changing. The university evolves, the policies will evolve. As I said before, we're a microcosm of the larger society. So, we live in a very litigious society, and, there are all kinds of protections, and there is trepidation about using these informal processes in a way that might expose the university's liability. We have not done restorative justice training That doesn't mean that we can't. We do offer a restorative justice course to our students. At John Jay, we do have a dispute resolution program for our students. They get a certificate at graduation. They're required to take an overview course, which introduces them to conflict and its resolution, a skills class, and depending on who's teaching it, it usually includes all kinds of communication skills, mediation, and restorative justice. There is an internship where they get to apply their skills at different agencies and contexts. Some of them are actually doing mediation, some are observing them, some are using their skills in a wide range of different contexts. It's amazing how many agencies in the city are offering mediation, whether it's the New York State Attorney General's office that offers mediation on consumer disputes. It's also true, for example, for used to be the DCA, the Department of Consumer Affairs, and now it's called the DCWP, the Department of Consumer and Worker Protection, offers consumer mediation, as does the Better Business Bureau. Our students are the ones who are handling all of those cases. There are those who are in divorce mediation programs where they've been trained in addition to the training that we offer on our campus. They've gotten 40 hours of training through the divorce mediation group, and then they get to observe every Wednesday night, which is wonderful for the students. A few of them have decided this is just too complicated for them to engage in at this point in their career, but they've truly learned a lot. Some of them are in the high schools where there are restorative justice programs. Some are in the community at the Red Hook Community Justice Center where they do restorative justice. They're at the community mediation programs. Over the years, they've been at the CCRB, the Civilian Complaint Review Board, which mediates between civilians and the police, at the EEOC, where they mediate sexual harassment type cases. They're at the Southern District, U.S. Southern District Court, where they usually help out the mediators there. Most recently, since the pandemic, they've been helping them with all of the technical help to do online mediation there. So the list goes on of all the places that our students are at. And then the fourth course that they have to take as part of the requirement is a selected topics course. Depending on which course they choose, they can choose a meditation course. And I'm really impressed at how good some of our students have gotten at learning how to relax themselves in order to deal with all kinds of situations. They can take a restorative justice course, or they could take a cross-cultural negotiation course. So it's sort of up to them on which course they take. That's for undergrads. On a rare occasion, we've had those who already have their undergraduate degrees come in. It does mean taking undergraduate coursework. I usually recommend that individuals consider taking the training from the community mediation programs that I mentioned before. They usually offer somewhere between 24 and 40 hours of mediation training. And I believe that HEOs can get professional development money to do that at CUNY. I'm not sure that faculty have figured out a way to get funding to take the training, but that is another option. Of course, we could always explore ways to go back to those models of perhaps a 1 day or a 2 day training. It's hard to sustain 5-day trainings when everyone has all kinds of busy schedules, but it seems relatively easy to do the 1 day training. As Lizette mentioned, I do run a monthly breakfast since 9/11. It's the round table for conflict resolvers up until March 2020. We met in person at John Jay for breakfast on the first Thursday of the month between 8:30 and 10 over coffee and bagels. It was free to everyone. Since 2007, we've been co-sponsoring it with the Association for Conflict Resolution of Greater New York. And since April 2020, we've been holding them online. So people from around the world literally have been joining us every month and encouraging us never to go back in person because they get to participate in a monthly talk because now it's online. We've been drawing from people from all over the place to join us. I also have a listserv for conflict resolvers. I'll put my email in the chat. Feel free to email me. I will put you, just say listserv. You'll get every posting of every training and job announcements and events, you name it, that is of interest to conflict resolvers. And occasionally it flares up big time, and you'll get to see how conflict resolvers don't manage their own conflicts as well. You know, they sort of don't practice what they preach, but they are animated, and it's really important that we support freedom of expression for everyone, as long as everyone's respectful, and so far everyone has been. It is a wonderful opportunity for people to share their concerns, ask questions. And yeah, I mean, those are two really important offerings from CUNY. Feel free to send me an email. I will put you on the listserv, which will also send you the announcements for the breakfasts. Another resource that you might find of interest is mediate.com, where all kinds of really short, it's the closest thing to an online blog, but they are short articles that people post almost on a daily basis and on all kinds of topics, and you can get a real quick read. It's not a refereed reading list, hasn't gone through any sort of editing, but people post some really interesting stuff, and it is a quick read for everyone to check on. Is there any final question? I know that we're at that 8 o'clock point and we've gone a little beyond it.
I just want to suggest something, Maria, and for everybody here from the PSC and the leadership. I think that it will be great to go back to what Sammy Henry suggested in the chat about having PSC mediators. We should explore that because that will nip in the butt things before they escalate and before they become so overwhelming that we can no longer, there's so many layers, like you said, in the onion, that it will be unbearable, that like so many people have been enduring the problems at this point. We see it from the beginning and we keep quiet and we don't do anything about it. So if we will have the trained mediators in our office of the PSC that people will feel that they can trust, I think that that could be something that we should explore. So I really thank you, Maria and Sammy, for raising that issue.
Mhm. Okay, I'd like to thank Dr. Volpe for her very inspiring talk. And I hope that we really enjoyed it. I'd like to thank the Anti-Bullying Committee of the PSC for shedding light on all these topics that we've discussed this year. And we hope to continue these programs as we try to strengthen our goals and achieve our goals for dealing with workplace bullying and decrease workplace bullying at CUNY. Thanks everyone for coming and have a good evening. And we're so happy that you came. Take care.
Thank you, Dr. Volpe. Thank you.
Thank you.
Here.
Great
Thank you,
seeing
Maria.
everyone.
Thank you, everybody, for coming. Bye-bye.
Bye-bye now.
Bye now. Bye.
Bye.